that my auditor is not able to access his office. My auditor is not able to reach out to his computer. I am not able to give my details to the officer. So, my lord, these are the situations. What will happen to the other human beings? Our officers are also human beings. So, my lord, this was the prevalent situation in tax. Not every hearing was adjourned. This was the situation for 2 years. Now, please see. So, it is both ways. The timelines is not only for us. It is also for them for filing returns, for compliances, for reporting, for giving the data, giving everything. Time has been extended. Now, please see page 3773. The Act came into force with a twofold objective: to relax timelines for both compliances and completion of proceedings. When Ashish Agarwal was heard in May 2022, the world has not got out fully from the impact of COVID. The backdrop, the basis, and the circumstances should not be lost sight of in 2024. This Honorable Court on numerous occasions had invoked its constitutional power under 142 in extending or relaxing timelines beyond the provisions of statutory enactment. But I'm not reading Prakash Corporate. Yesterday I read it. There, my lord, this court said, in spite of return statements being filed late, in spite of the statutory prescriptions being to the contrary, we will still condone. But my last section, please come to paragraph 40. But why I'm reading these 4 parts alone is, paragraph 78, page 40. These 2 are constitutional bench judgments, but directly addresses my entire contentions of what they have been laboring to say that you please set that not the Ashish Agarwal judgment. One is Union Carbide constitutional bench. Para 83. It is necessary to set at rest certain misconceptions in the arguments touching the scope of the powers of this court under Article 142(1) of the Constitution. These issues are matters of serious public importance. The proposition that TOLA is of public importance, please bear that in mind. The proposition that a provision in any ordinary law, irrespective of the importance of public policy on which it is found, operates to limit the powers of an apex court under 142 is unsound and erroneous. The power under 142 is at an entirely different level and of a different quality. Prohibitions or limitations or provisions contained in any ordinary laws cannot ipso facto act as prohibitions or limitations on the constitutional powers under Article 142. Such prohibitions or limitations in the statutes might embody and reflect the scheme of a particular law, taking into account the nature and status of the authority or the court on which conferment of powers limited in some appropriate way is contemplated. The limitations may not necessarily reflect or be based on any fundamental consideration of public policy. So-and-so learned Attorney General said, limitation of the powers under 142 arising from inconsistency with express statutory provisions of substantive law must really mean and be understood as some excess prohibitions contained in any substantive statutory law. He suggested if the expression prohibition is read in place of provision, that would perhaps convey the appropriate idea. But we think such prohibition should also be shown to be based on some underlying fundamental and general issues of public policy and not merely incidental to a particular statutory scheme or pattern. It will again be wholly incorrect to say powers under 142 are subject to such express statutory prohibition. That would convey the idea that statutory provisions override a constitutional provisions. Perhaps the proper way of expressing the idea is that in exercising powers under 142 and in assessing the needs of complete justice of a cause or a matter, the apex court will take note of the express prohibitions in any substantive statutory provisions based on some fundamental principles of public policy and regulate the exercise of its power and discretion accordingly. The proposition does not relate to powers of the court under Article 142, but only to what is or is not complete justice of a cause or a matter. And in the ultimate analysis of propriety of the exercise of power, no question of lack of jurisdiction or of a nullity can arise. Justice M. N. Venkataraman, Chief Justice. Please come to the second judgment. Right, para 16, Ashok Kumar Gupta. It would be seen there is no limitation under Article 142(1) on the exercise of the powers by this court. The necessity to exercise the powers is to do complete justice in the cause of a matter. The inconsistency with statutory law made by the Parliament arises when this court exercises powers under 142(2) for the matters enumerated therein. Inconsistency in express statutory provisions of substantive law would mean and be understood as some express prohibition contained in any substantive statutory law. The power of 142 is a constituent power transcendental to statutory prohibition. Before exercise of power under 142(2), the court would take that prohibition into consideration before taking steps under 142(2), and we find no limiting words to mold the relief, or when this court takes appropriate decisions to mete out justice or to remove injustice. The phrase complete justice engrafted in 142(1) is the word of width couched with elasticity to meet myriad situations created by human ingenuity or cause or result of operation of statute law or law declared under 32, 136 or 114 of the Constitution, and cannot be cribbed or cabined with any limitations or phraseology. Each case needs this examination in the light of its backdrop and the indelible effect of the decision. If the ultimate analysis, it is for the court to exercise its power to do complete justice or prevent injustice arising from exigencies of cause or matter before it. The question of lack of jurisdiction or nullity of the order of this court does not arise. As held earlier, the power under 142 is a constituent power within the jurisdiction of this court. So, the question of law being void ab initio or a nullity or voidable does not arise. Third, Shilpa Shailesh, para 8. Given the expansive amplitude of power under 142(1) of the Constitution of India, the exercise of power must be legitimate and clamors for caution, mindful of the danger that arises from avoiding an individualistic approach. 90,000 notice here has to exercise of constitutional power. By 9, this court is again a constitutional bench. Even where positive law is clear, the deliberately wide amplitude of the power under 142 empowers a court to pass an order which accords with justice. For justice is the foundation which brings home the purpose of any legal enterprise and on which the legitimacy of the rule of law rests. Last, State versus Kalyan Singh. Para 22, this is by Justice Nariman. Article 142(1) of the Constitution of India had no counterpart in the Government of India Act 1935, and to the best of our knowledge, does not have any counterpart in any other constitution world over. The Latin maxim, fiat justitia ruat caelum, this maxim quoted by so-and-so, the passage in which it is quoted makes interesting reading, and amongst the many things stated by the great judge, it is stated, I wish popularity, but it is that popularity which follows, not which is run after. It is that popularity which sooner or later never fails to do justice to the pursuit of noble ends by noble means, is what comes to mind on reading of 142. Let justice be done though the heavens fall. This article gives a very wide power to do complete justice to the parties before the court, a power which exists in the Supreme Court because the judgment delivered by it will finally end the litigation between the parties. By 142, as has been held in State of Punjab, etc., judgment equity has been given precedence over law. But it is not the kind of equity which can disregard mandatory substantive provisions of law when the court issues direction under 142. While molding relief, the court can go to the extent of relaxing the application of law to the parties or exempting altogether the parties from the rigors of the law in view of the peculiar facts and circumstances of the case. This being so, it is clear that this court has power, nay, the duty to do complete justice in a case when found necessary. Last two paragraphs. When this honorable court has held in white para 8 in Ashish Agarwal, revenue cannot be made remediless and the object and purpose of reassessment proceedings cannot be frustrated. Any attempt to upset, reverse or nullify this reasoning should be totally eschewed. This entire assessment process and the scheme to follow as directed by the judgment cannot be held redundant or nugatory or purposeless. For any reason, should this honorable court feel there is a vacuum that needs to be filled in Ashish Agarwal, every attempt should be made to fill the vacuum to effectuate the invocation of the constitutional power with the sole objective not to render the revenue remediless. Without prejudice, it is respectfully submitted if this honorable court is posed with the option of either to declare Ashish Agarwal as redundant or to effectuate the same by filling in the void or the vacuum, if any. This honorable court should only choose the latter and not the former, since the power under 142 is the original power. Source of it is traceable to the Constitution to do complete justice. The journey under 142, which began as Ashish Agarwal to render complete justice, with a definitive objective to ensure revenue is not made remediless as against 90,000 notices issued by it should reach a complete fruition and finality through this judgment of this Honorable Court, thus fulfilling the constitutional mandate envisaged under 142 of the Constitution of India. Lord, we rest our case at this. And extremely obliged, Lord, for an extremely patient hearing and indulgence. A very heartfelt hearing by this Honorable. Deeply obliged to all the three judges. Thanks.
Yes. Just a couple of things. As I had said initially, there are 4 categories. There has been a lot of confusion by clubbing all the categories together.
Yes.
The first category, 13, 14, 14, 15. The point over there is...
Just one second.
Then I have to, this was what he argued and I addressed. And I've said all these 4, same 4 he's going to restart again. I'll still, my lord, not sorry.
It's 4 categories, 13, 14, 14, 15.
1 second.
Where what has to be tested is when the notice under 148 was issued in July, August 22, was it barred by virtue of the first proviso to section 149(1)(b) of the amended provision. Second category is 15, 16, where notices are issued under the unamended law. My learned friend in his note at page 25 says he wants to segregate this lot of 15, 16. So just see page 25, what my learned friend says. I'll come to that in a moment.
We'll just keep the submission. I'll just argue on first principle.
Third category is assessment year 16, 17 and 17, 18. Where what my lords has to see that on the date when the notice was issued, who was the authority that had the power to pass and to sanction the order under 148 AD, and the notice
Was the authority?
who had the power to sanction the passing of an order under 148 AD and the issuance of a notice under 148. And the last category is where the initial notices were not challenged before the Supreme Court or before the High Court. Would their cases be governed by Ashish Agarwal?
Now what we do is, we'll go to each one of these categories. You can give us bullet points of your what you've already argued, so that we just make a note of it and we'll close it there.
Now, just one, before this, I go to that. Was this mess, if I may use that term, has been created because of 2 things. But one is the explanations to the 2 notifications, which said that when you issue a notice after 1st April 21 and before 30th June 21, you will apply the old law. That was a mistake on the part of the government, on the part of the delegate, when he exercised its powers.
Explanation to the 2 notifications
Stating that you will apply the old law when you issue notices under 148 in the extended period of limitation, up to from 1st April 21 to 30th June 21.
Just one second. Under extended period of limitation from
1/4/21 to 30th June 21.
Yes.
Court's judgment in Ashish Agarwal, and once again reiterated the travel back in time.
I've given it up.
I will.
No, but I've given it up.
Yes,
I
yes,
don't know
but
what
let
the
me
points
now.
we made. I've given that up.
Why was a problem created
Reiterated the travel back,
in time theory,
which meant
that the notices have to be judged. This is the law prevailing on 31st. It is based on these instructions that the officers acted in the manner in which they did, and their action was sought to be sustained in all the high courts below. My learned friend undoubtedly has not canvassed these arguments before my lord, but my lord will keep in mind, if my learned friend's argument is that my lord should invoke 142 and save all this. But please keep in mind that this was on their own choice. It was their acts which have led to this problem. If 142 is to do complete justice between the parties, why should the SSC suffer as a consequence of the action of the government and the Central Board of Directors? It was a principle. The precedent of Ashish Agarwal under 141 is what? They approve of the views taken by all the high courts. That's what they say in para 7. That we approve of the views of all the high courts, that you cannot apply the old law. And you have to look at the law as it stands when you issue the notice.
Venkataraman, sorry, just don't sit also, just wait. Your argument on sanction will determine the outcome for which years.
All years.
The sanction, according to that.
Well, all those intertwined. They may say, I'm messing it up with putting it in one basket. You can split it in not 4 parts, you can split it in 40 parts. The issue remains the same. The spirit runs the same.
The issue will cut across all years.
Sanction issues there only in category 2 and category 3. Sanction is only in those two. 15, 16, 16, 17, 17, 18. That's it.
And not 13, 14.
Not at all.
That I have already explained. That 6 years is already available. That is not a problem. But
So therefore he is right. That sanction
13,
is
14,
right.
14, yes, but what will sanction will still, the difference, the legal difference I'll just spend. My friend makes omnibus statement. There is a point to it. This will have an impact on 13, 14. My lord, sanction is on 2 points. 6-year sanction and 4-year sanction. So if 4-year sanction is saying that you can't give a sanction under 151, then the time limits of 6 to 8 will also go, because I can't give a sanction at that same statement 151. How does he make a convenient statement? 13, 14, 14, 15 will not. I have to, as a revenue council, I have to stand up. It will have an impact on both completely.
We'll backtrack where we left you. Ashish Agarwal, you said in para 7, approved the views of the High Court that old law cannot be applied.
And the law prevailing on the date when the notice is issued has to be applied.
Yes.
Ashish Agarwal group of cases covered 5 assessment years, 13, 14 to 17, 18.
Yes.
When the court was molding the relief in terms of Article 142, it could have bifurcated it year-wise and given directions year-wise. That was one alternative which was available to the court.
Yes.
The second was what the court adopted, that we are giving directions that you convert the 148 notice into a 148AB notice, follow the procedure thereafter. But at the same time, said that all defenses are available to SSEs, not once, but 3 times in the judgment, right, twice in the judgment, not 3 times.
Yes.
Therefore, the interpretation which my learned friend now seeks to put on it is that the judgment or the Article 142 relief which was given to the revenue will be set at naught if the views taken by the courts below is upheld, is wrong. Because what Ashish Agarwal did was, yes, we are giving you directions for 4 years. This point of limitation applies only for 2 years. 13, 14, 14, 15 and 15, 16, 3 years. But I don't think any of the 15, 16 cases are before my law.
4 has become 3. I've conceded in my note itself. 15, 16 is gone because the time limit.
My lords, what will survive on limitation will be 16, 17 and 17, 18.
Please record, you see, conceding on behalf of the entire trade. 13, 14, 14, 15 is not pressing then on limitation.
Pressing. But I am pressing.
But this is, however,
So we are recording your concession as in the note.
15, yes, 15, 16, because 4 has become 3, my lord. I can't use, my lord, normal time limit I cannot invoke. If 6 years is there, that is left open. But normal time limit I can't invoke. It will be because TOLA was not there then. That I put it in my writing. Similarly, your lordships can say all notices, Lord, threshold 50 lakhs, this 1 lakh to 50 lakhs, please say in the judgment. We have said it in the clarification, but please say in the judgment. It will help assessees. If you are invoking 6 years or the threshold cannot. Yes, for 3 concessions, your lordship can straight away.
Just take your concession.
Yes, straight. But 15, 16.
Just 1 second.
Yes.
1.
I'll just take 3. I'll read the 3 concessions.
So just go slow and read it out.
Yes. 1 minute. 1 minute. I have recorded the concessions. I'll just read that straight away and you can lodge. Yes. Lord, page 435, volume 3.
Formulated.
Yes. 1, my lord. Lord, 4 years stands reduced to 3 years.
Just formulated now.
Yes. 3 concessions, as in law. When I say concession, we are not disputing this. Because of the new amendment, 4 years has become 3 years.
1 second. Because of the amendment to section 149.
1. 4 years gets reduced to 3 years. And 2, Lord, in terms of 149(1)(b), threshold from 1 lakh has become 50 lakhs. So when we do in short, my lord, wherever because we invoked the old law and issued notices, so we would have applied the threshold of 1 lakh. Please substitute that with 50 lakhs threshold. Notices under the extended period of 6 years,
1 second. Yes.
and if invoking 6 years, under the old law, originally 1 lakh, now stands enhanced to 50 lakhs. So all notices of 6 years less than 50 lakhs had to be dropped. Lordship may say it in the judgment. You have said it in the circular, please say it in the judgment. Therefore, there is no confusion by any AO in this country. It's the second concession, my lord.
1 second.
Yes.
So all notices.
Issued invoking 6 years and less than 50 lakhs will have to be dropped automatically.
Yes.
And third, for 2015-16, because of the reduced time limit of 4 to 3 under the new law, we would have issued it under the 4-year law plus TOLA, because we invoked the old law wrong. We have to apply the new law
Due to the
due to new 149 reducing 4 to 3 for the financial year 2015-16. Sorry, I stand corrected there. Assessment year 2015-16, 3-year time limit expires on 31/3/2019.
1 second. Yes, absolutely.
Yes, and TOLA was not there. TOLA came only in 31/3/2020. So originally we would have issued it as 4 years and subsumed it by invoking TOLA. That's wrong. 2015-16 by virtue of the new law will automatically stand excluded.
Yes.
These three, your lordship, make it part of the judgment, my lord. Let there not be any ambiguity. Deeply obliged.
Just 1 second.
Deeply obliged.
Yes. Yes, Mr.
My lord, based on my learned friend's last concession, therefore, second category, if my learned friend says the SLPs will have to be dismissed. Very good.
Provided the second category is only on 15-16, 3 years.
No, it is 15-16 notices issued on 31st of March 21
1 second.
or prior to 31st. After 31st March 20, before 31st March 21.
I'm not only one, well, I make it very clear.
Notice for KY 2015-16, notices issued.
From 1/4/2021 to 36, my lord, will certainly be barred beyond 3 years.
But that is not there before my lord.
No, we don't know. It's there. We have cases, we have cases. But my friend is articulating something else. That is different. We are not giving concession there. What my friend wants to know is, well, I make it clear. Notices issued from 1/4/2021 to 36/2021, invoking the old law, 2015-16 is gone.
4 years came down to 3 years.
3 years. Now, suppose I've issued the notice invoking TOLA prior to 31/3/2021, then I had 4-year time limit under the old law. That I'm not conceding. If my friend is second category is that, I'm not conceding. That is old law. We are not, because that is a notice which is prior to 31/3/2021, not within this bracket of Ashish Agarwal at all. That is a normal notice. He has to go and prosecute it. Don't bring Ashish Agarwal near it.
So, my lords, I now take up category 1 for.
Okay, just summarize in bullet points.
Yes,
Because now.
absolutely.
But just, that's why we are doing it carefully so that nothing is missed out. Yes, category 1.
Notice has to be.
Just 1 second. Let's go step by step. You can tell us for each category. We'll take it in bullet points now.
Right, man. The first point is that notice has to be tested based on the law prevailing when the notice is issued.
Yes.
Notices are issued in July and August 22. So the law prevailing is that 149(1)(b) proviso applies.
1 second. Yes.
Once the proviso applies, you have to see what was the time limit under the old provisions as they then stood. The time limit under the old provisions was 6 years. It got over on 31st March 20 and 31st March 21.
Yes.
The proviso under the amended law did not use the phraseology under the provisions of 149 as they then stood as extended by TOLA.
Yes.
As was used in that second notification, notification 38, my lord will recollect. It said, as per extended as per TOLA and extended by the notification.
Yes.
That's assuming on a demurrer, you read in the extension by TOLA also into 149 as it existed under the unamended law. Nevertheless, that will take you only up to 30th June 21. It cannot extend it to August 22.
Just to include that between 30th June and 4th May 2022.
Under what provision?
Judgment of
But under what provision? No, Ashish Agarwal does not.
But the thing is that if either we give effect to Ashish Agarwal,
So I will-
right or wrong,
I will
that is
deal-
now a judgment. Which
No, no,
therefore,
I appreciate, my lord. Therefore, Ashish
because
Agarwal.
nobody has challenged Ashish Agarwal. It's a then finality now. All these
But
years.
therefore, why did Ashish Agarwal say the period of limitation is open? The defense on limitation is open.
Does that then? But then why was the exercise in?
Because as I said, there were other assessment years also. 16,
That was-
17, 17, 18.
Yes, not any number of time my friend repeats, I have to resist it. But they belong to the same bracket. I'm so sorry. I have to, he's doing the 10th time, I'm also repeating, I'm troubling the growth. 4 and 6, the logic is the same. My friend is trying to make a disconnect every time. I'm so sorry. Can't do this.
My lord,
So you are saying a student on a demerit that extension by TOLA is read in. It takes one only till 30th June 2021 and not until August 2020. That's the category.
that's right.
Anything else in this category? Or?
Just 1 minute. I'll do that.
Huh?
My lords, just to answer a query which fell from my lords under Chief Justice. My lords, 16, 17 and 17, 18, which was part of the Ashish Agarwal batch, the time limit under 149 1B read with the old provision would have been 31st March 23 and 31st March
6
24.
years, my lord. Not for 4 years. I have not invoked 6 years. I've invoked 4 years. Any number of times he'll repeat it. I'll have to resist it. He can't do this, my lord. My friend has to, can't do this. I'm on a 4-year time limit with TOLA. I'm not on 6 years. Very unfair.
That's category 1 we have done.
Right. You know what I'm just 31st March. My lords, what Ashish Agarwal said is that because Ashish Agarwal was delivered in May 22, and the old provisions were applied in 21. So Ashish Agarwal said, now you're issuing a notice under 148, you follow the procedure. So they could have followed the procedure under 148 under the amended provision and issued a notice within time. There was no defense of limitation left.
Out of 90,000 notices, let him show one writ petition of that nature before he makes a statement and defends it. It's all utopian statements.
Lords, all the 16, 17 category cases are cases where they have been sent back by Ashish Agarwal. All the 60, my learned friend has not bifurcated.
Now let's go on to category 2.
Right. Category 2 is assessment year 15, 16.
Yes.
Lords, these are cases where notices have been issued between 31st March 20 and 31st March 21, where sanction has been obtained under 151 subsection 2 of the unamended provisions. Sorry, the submission to my lords before my lords was
Also, under 151(2) of the unamended provision.
that's unamended provision.
Yes.
Lords, 151(2), as my lord put it, says no notice under 148 shall be issued. The time limit is for issuance of a notice. If you are issuing a notice before 31st, within 4 years, then a particular authority is specified. If you are issuing a notice beyond 4 years, another authority is specified. Now then, please see the language of 151(2) as it existed under the unamended provisions. Now just go back to page 355. No, not 355, sorry. 356.
Another 10 minutes or so.
Lordship, your Lordship will be taking up.
Demolition matter, my lords,
Sorry.
will take it up. The council is also logged in online. They have virtually demolished most of the walls.
Give us the
Yes.